Добрый день, уважаемые коллеги и гости.
Dear colleagues, dear guests, good afternoon. I now declare the session begun because the link has been established with all members of the Dissertation Council. Our session will focus on the dissertation by Grigory Vaypan, the principle of proportionality in international law, speciality 120010, international law. My name's Ivan Makutumov. I am Doctor of Law, Head of the Department of Logic, St. Petersburg State University, appointed the chairperson of this Dissertation Council. Allow me to introduce my colleagues on the panel. We will follow the alphabetical principle. Martin Koskaniemi, Helsinki University, present here, whose participation has been officially confirmed by the order of the St. Petersburg State University. Vera Usinova, Department of International Public and Private Law, Higher School of Economics, who will be joining us online. Elena Timoshina, Department of the Theory and History of State and Law, St. Petersburg State University, and Vladislav Solstik, Department of International Law, Novosibirsk University, who will also be joining us online. As we know, according to Federal Law 127 on research and research policy, St. Petersburg State University is entitled to award academic degrees following a special procedure. The session is considered valid if joined by at least 2/3 of the Dissertation Council. We have 5 colleagues on the panel, so the quorum is present. Let me announce the agenda for our today's session. It is not 100% obligatory, but I would like you to adhere to it. The session of the dissertation panel may not take more than 2 hours. It will be opened by the statement on the part of the chairman on the documents presented. Then the author of the dissertation will be allocated 15 minutes to present the key provisions of the dissertation. Then, following a brief question and answer session with the visitors, reviews by my colleagues on the panel will be presented, followed by responses by the author of the dissertation to all the questions and critical comments. There will be some time allocated for the open discussion. Those that wish to participate in the discussion must place their names on a special list displayed here. Please make sure that you introduce yourself before the beginning of your comments during the open discussion. The author of the dissertation, the defendant, will be given some time to respond to the comments from the audience. This will be followed by a discussion by the members of the Dissertation Council. The vote, then the results of the vote will be announced, and the defendant will be given several minutes for some final comments. Please make sure that your mobile phones are turned off or switched to vibrate or silence. Simultaneous translation is being provided into English and Russian. Allow me to proceed to the first part of our agenda and list the documents that have been submitted for the defense. Statement from the defendant addressed to the SPSU rector. Documents confirming the successful passing of PhD examination. Always excellent marks. The list of publications, including those printed in editions recommended by the National Attestation Committee. And several orders issued by St. Petersburg State University, order issued on the 7th of March about the acceptance of the dissertation for defense, and an order issued on the same day appointing the members of the Dissertation Council. All the documents are in conformance with the established requirements. The dissertation is submitted in Russian and English in the paper format in accordance with the existing governmental standards. Do you have any questions regarding what I have said? Nobody does. After no more questions, allow me to proceed to the second part of our agenda, namely presentation by the defendant. Good afternoon. Can you hear me well? I can hear you well. Welcome to this session, defense session, on the day of the Red Cross and the Red Crescent. The 8th of March is celebrated as the International Red Cross and Red Crescent Day, being the birthday of Henri Dunant, a famous Swiss specialist and founder of the Red Cross and the Red Crescent organization, one of those persons whose ideas have changed the world. This defense and this dissertation is about the ideas that lawyers, we international lawyers, and lawyers on the whole, are governed by at the beginning of the 21st century, the language that they use. As an example of this universal ideas, I have studied the principle of proportionality. The proportionality principle is very amply described by Bassanio in Shakespeare's The Venetian, The Merchant of Venice. According to the text by Shakespeare, is to do a little right, to do a little wrong. So this, a little wrong, is admissible for greater good. So the intrusion into the rights of one subject by another subject is admissible to achieve a higher goal. However, this is only admissible when it is done for a greater good and when the harm is relatively small. So this is the key idea underlying proportionality. The proportionality principle is present everywhere, in international law, in constitutional law, in administrative law. Aaron Barak, the former chairperson of the Administrative Court, Israel, called our epoch the epoch of proportionality. Proportionality is considered by us lawyers not only as just another principle or just another provision in law, but as a unifying, universal idea. One lawyer named proportionality the highest degree of the supremacy of law. There is a lot of enthusiasm about proportionality. It is often referred to as a success story because this concept makes law more alive without compromising it as law. When I was writing this dissertation, I was surrounded by really understanding and polite people. So nobody asked me this question directly, but I know that it was literally hanging in the air. The question that they never asked was, why can't you just write about a usual dissertation about the principle of proportionality? Why should you focus on proportionality from the tenets of critical methodology? My dissertation is based on and uses the methodology of critical structuralism. So I would like to build my brief presentation as a story of the dissertation, of the work that I have written, but also wanted to make this contrast with the dissertations that I never wrote, so that you can understand the dissertation that I did write better. One of the founders of critical legal studies, professor of Harvard School of Law, Duncan Kennan, wrote that critical research, a critical study, begins when you see a conceptual difference or a contrast in law which makes you crazy, which drives you mad. You read works, you listen to samples of legal discourse, and you see some contrasts. You see contrasts of facts and values, for example. And you understand that lawyers do lay great emphasis on this conceptual contrast. You feel that there is something wrong. This is the beginning of critical research.
And now I would like to say about what could have been there in my dissertation and what is not there. Those are three critical points. The first of them, well, I could have made it a standard dissertation that is normally presented in Russia and abroad. I could have stipulated the nature of proportionality. I could have provided answers to what proportionality is. But once I started to develop an insight into this dimension, I saw that lawyers split in two types. The one group thinks that proportionality is a principle, it is legally mandatory. The others, on the contrary, believe that proportionality is a method, it is a tool, an analytical structure that does not produce any legal solutions in its own right. So those are the two views. A regular dissertation should have provided an answer to which of these points, which of these groups is correct. But as soon as lawyers cannot agree on the definition of proportionality, this leads us to the solution that possibly there is no such definition at all to what proportionality is. The next thing which is lacking, which is not in my dissertation, I could have written an overview, a historical background of proportionality principles, showing how it emerged from the most primitive form to the most complicated concepts, tracing it back to the ancient Greece, the ancient Rome, through the Middle Ages, the New Times, the Enlightenment, thus reaching the most complicated form of proportionality, one with the development of international law. But once I started to analyze the sources, the outcomes of proportionality, I observed that until the 20th century or the mid-20th century, there was no notion of proportionality at all, or such idea as proportionality. I mean, the idea of a balance. In the 18th and the 19th century, this idea by lawmakers was interpreted in an absolutely different way, as opposite to lawyers of the 21st century that tend to relate proportionality to pragmatism, to law and politics, to international law and its social dimension. All of these concepts are alien to lawyers of the 18th or 19th century, and I could speak more about that on the margins of my dissertation, of my defense. Therefore, the idea of my dissertation is to present proportionality not as a universal or a neutral idea, but on the contrary, as a context, as something which is responsive of the context, which is closely related to specific lawyers, specific projects, and specific facts. And therefore, the evolution of proportionality is not the evolution of ideas, but it is rather a gap in the evolution of these ideas and in the evolution of the concepts of international law. And lastly, the third thing which is lacking in my dissertation is that there is no content of the proportionality principles. What does the proportionality permit? Or what does it not permit? But it's not there. But because once I started to analyze this principle, I saw that that proportionality is not a uniform idea. It is ambiguous. It can be split in two different ideas. Despite the versatility of terminology, I mean, the deep structure of this concept can be derived to the two types of proportionality. The first being proportionality as a proportion between benefits and harms. On the contrary, there is a different idea of proportionality, interpreting proportionality as a proportionality between the means and ends. An evil, an intrusion into someone's rights, or abuse of someone's rights for the benefit, for some other benefit, without transgressing the margin of this benefit. So proportionality as a necessity. And what we see is that those are two contradictory concepts. Proportionality as facts, proportionality as values, on the other hand. So the bulk of my dissertation looks into the existing industrial doctrine and judicial practices, looking into how lawyers and specific arguments present these two contradictory concepts of proportionality. There are some court cases. For example, the sanctions case, that's the arbitrage case between France and US, the so-called air service case, which is well known, the case between Pan American and Air France. So we see how two concepts of proportionality clash with each other. Proportionality as a necessity and proportionality as something equivalent. And what we see is while the parties develop their arguments, they kind of swap their interpretations of proportionality for the sake that none of these concepts is able to ensure some third space, some golden middle. This is basically what it was initially behind the principle of proportionality once it was established by lawyers. What we see is that these two oppositions subvert the arguments without allowing the parties to answer the question on what proportionality is and dragging both parties into endless argumentation. This is basically what is behind the critical method, namely to show the endlessness of legal argumentation and to switch my focus from law to legal discourse and to how lawyers speak about legal ideas. There is no objective, unbiased concept of proportionality or of law. Therefore, my idea was to change my focus to argumentation, to argument structure instead. So, this is done not by chance. It is not whimsical, not occasional. It is done just because, in my understanding, this, after all, provides some solution to some research objectives and some applied objectives, opening up a new perspective in law. So instead of thinking what answers are right, I mean what proportionality is, what is behind proportionality, instead, I venture to analyze how to defend proportionality and why any interpretation would be both legally solid and legally vulnerable at the same time. I see that I have exhausted my time limit. Therefore, I would like to rather keep my other ideas for the discussion. Thank you so much. Now let's have the Q&A session. Please ensure your questions are brief, and before asking your questions, please introduce yourself. Any questions?
Да.
The mic, please. The speaker is not speaking into the microphone. Interpretation is impossible. Yes, please should speak into the microphone. That's right. To ensure you have interpretation. Please, first ask your question. Ask a question first. Yes, go on. Where's the mic? Do we have any spare mics? Please, here's the mic.
Да, конечно, как-то страшно и почетно первый открывать сессию вопросов, но мой вопрос довольно-таки злободневный характер,
Well,
потому
my
как меня
question
в большей
is,
степени
I think
интересуют не
it's a
вопросы
burning question.
воздушного пространства между
I'm
США
not so
и
much interested
Францией,
in
хотя
how
тема
France
тоже
and US
интересна. Меня
share
больше
the
волнуют
airspace, although it is a
вопросы,
highly
происходящие непосредственно
exciting
в России,
issue.
и в
But
частности
I would like to focus on Russia and what's going on in Russia and in St. Petersburg in particular. I represent those who were detained on May the 5th in Moscow and in St. Petersburg as a result of a rally. There were lots of people were arrested because they participated in unauthorized protests. So therefore my question, how could you apply the proportionality principle in relation to such cases? And yet another comment. On Sunday, I saw that the judge who decided to jail a person for 7 days because this person failed to hear the warning of the police as an evil deed. And the judge had such inscription on her badge, dura lex sed lex. So therefore formally, I think that therefore, so this judge just delivered such a formal decision. But looking at your dissertation, considering the context of your dissertation, I believe that law is not, or human rights are not something that should be interpreted by way of law, but it is proportionality as a principle and as a method. Although your dissertation also notes that the margin of appreciation principle that can be abused easily. So what's your take on that? Thank you so much for the question. Okay, so we are amid practical challenges right away. Well, you see, the situation referred to by Olga, the lady who asked this question, subverts proportionality as the principle of the rule of law. Lawyers in different judicial institutions implement the concept of proportionality in a different way to exercise their interests. One of such institutions is just over the river, which is the Constitutional Court of the Russian Federation. Over a year ago, the Constitutional Court of the Russian Federation justified that liability for an unauthorized protest is a violation of law. And in such a decision, the Constitutional Court was guided by the principle of proportionality, along with other principles. Therefore, my research exposes the contradictory nature of proportionality. Any decision that legal decision that refers to proportionality principle would be legally correct, legally relevant, and legally vulnerable at the same time. Proportionality is not a dummy. It is not just legal engineering or plotting. Proportionality, rather, is about how strong legal arguments are. Therefore, my dissertation is a critical research because I oppose force and argumentation. Argumentation is force itself. So arguments can be provided in the courtroom or outside the courtroom. It's not my favorite example, but once we started to speak about protests, well, a policeman says at a protest, urging citizens to go away and to free the street. This is about proportionality, by the way, because this means that some citizens should go away in order to let the way free to the other citizens. So this is the policeman speaking the language of proportionality. Therefore, once we consider some actions incorrect, this is counter-argumentation. So I look at how counter-argumentation develops. What are the rules of such counter-argumentation? And I show that in its development, the way counter-argumentation unfolds, it exposes its stereotypes. Therefore, lawyers who know these stereotypes, who are well versed in such stereotypes, can implement this concept for his benefit. More questions?
I have a small question regarding your explanations. In your logic, what are the criteria to differentiate lawlessness and law, arbitrariness and law? So what are the key criteria that enable one to differentiate between these? What makes us think about one court order as just and the other as unfair and unjust? Thank you. This is a very important question that is frequently asked by lawyers to themselves in the post-critical era, which is now. And it's also a question that is asked of lawyers who have written a critical research work. So by denying the possibility of correct answers regarding proportionality, we're left with no objective criteria, no legal criteria to differentiate proportionality. Correct proportionality from incorrect usage of the proportionality principle. So everything that we are left with as lawyers who have lost faith in different understandings of law at the beginning of the 21st century is, and I would like to refer you to Dr. Koskaniemi's work, is the intuition of the wrong. This is your own intuitive feeling of being in the wrong. It's the impulse that we all have. We may not always agree on these impulses. There are different things that we don't agree on. However, this work and this vein of research makes us want to listen to those impulses. So when they emerge, we can use legal instruments, the legal instrument of proportionality, to guide us on what proportionality is. So this is the answer. I don't have any better. Any more questions? Maybe our colleagues on the panel who have joined us online? No questions at this stage? Yes, so I have asked all my questions in my review. Yeah, same, ditto. After no more questions, allow me to proceed to our next stage. Thank you. You may take your seat, Mr. Vaypan. And let us focus on the external reviews. And I have two of these. The first was presented by Alexei Dolchikov, of St. Petersburg State University, Associate Professor of the Department of Law, Candidate of Sciences in Law. And the second is from Dmitry Krasikov, Head of the Department of International Law, Saratov Law Academy. The reviews are posted on the website, so let me now focus on the critical comments and the conclusions. I would like to begin with Alexei Dolchikov's review and some critical comments that he has. The subject of the dissertation is not quite consistent with the nature of the study because it's much more related to argumentation than the principle of proportionality in the legal system. This is largely due to the analysis of sources in English. Dogmatics are often ignored. And positivism, hyperpositivism, is the dominant type of legal thinking in Russia and must not be denied, must not be ignored. The author fails to include the understanding of the force of tradition and the context of this country, the national context. The Second Amendment to the U.S. Constitution on self-defense is related not only to the stability of behavioral patterns, but also to the spread of the individualism ideology in American society. So pragmatism is poorly suited to resolving social and legal problems. The author has not presented any overview of the concept of proportionality in international and Russian law. So the best review on the subject was written by Michael Kruger in 1984. There was another monograph on the weighting of sovereignty. There is another German publication that the author may have considered, including one by Anna Peters, or Anna Peters, director of the Max Planck Institute. It is hardly convincing. One not really convincing statement is regards to the principle of proportionality and supremacy of law in international relations. Similarly, proportionality is not given enough attention in connection with the decisions of the EC Court. The principle of proportionality cannot be reduced to pragmatism. The defendant fails to consider the key features of proportionality. Even though he quotes the American liberal doctrine, he fails to consider the French and the English conservative doctrines. His reasoning dissonates with many critical doctrines, and Given his deep analysis of the proportionality principle, the author's understanding of this principle is not the most modern one. The evolution of proportionality from elementary ideas to more perfect principles, excluding the lawlessness on the part of the state, is tantamount to the history of proportionality. The idea of proportionality, with its liberal roots, is unthinkable without analyzing the constitutional order. The author identifies several types of proportionalities: horizontal, vertical, and combined, and focuses on the de lege ferente principle. However, the placement of international law to the lower positions on the list demonstrates the author's position on the subject. Proportionality in national and its history in national law. Means limitations, restrictions on the power of the state to infringe on individual freedoms. The individual receives the right to apply to court and query the infringement on their individual freedom. The postmodernist discourse involved in the work only distracts one from these problems. The author uses interdisciplinary research. He quotes The Merchant of Venice by Shakespeare in his work. However, if you analyze the plot of the story, a full analysis of this play was given by Rudolf Hering at the end of the 19th century. Another work by Franz Viake on the principle of proportionality also quotes the story. The quote may be construed to affect the compensation principle, not too much, not too little. At the same time, despite these statements, at the same time, the defendant did not quote the sources where this interpretation of the Venetian merchant is present. There are few doctrinal sources coming from France or Germany in the work, despite the fact that these doctrines have had a major impact on the legal practices of the European Union. So what proportionality can we be talking about in legal argumentation? In the second case, the young Russian researcher, like many other English-speaking researchers, sometimes confuse the elementary concepts of German dogmatic law, such as differences in subsumptions. However, the German specialists are one of the trailblazers in the field of proportionality in international law. So the over-radical evaluation of positivism contradicts the understanding of proportionality as the key principle in this work. The author acts as a progressor here. However, such good aims very often lead to poor results. The author has managed to avoid some acute legal discussions relating to the current political events in Russia, and has focused on the governmental policy of Israel and Turkey. However, this reduces the value of the work to the Russian law field and the Russian socio-political concept.
Overall, the dissertation has to be drafted according to the national standard, whereas we see the violation of such standard in how the bibliography is done in the dissertation. Ultimately, the member of the dissertation board, me, basically believe that all these recommendations and points of criticism do not invalidate the overall expression of the dissertation. That was the review submitted by Professor Dolzhin. Now I would like to refer to the review provided by Professor Krasikov. So we see the following points of criticism. The author claims that the proportionality principle is the overall principle of human rights. This principle is conditioned by the presence of international agreements on human rights. However, we should note that in 2015, it was claimed that Provision 15, dating back to 1959, does not establish the proportionality standards and thus is not accepted internationally, which is followed by the Provision 17. What's more, in the Tallinn Guidelines on International Law, experts disagreed on the principle of proportionality as applied to the human rights. A number of experts accepted that proportionality principle is valid for some specific regional context and legal context, whereas the other group of experts claimed that the proportionality principle is not solid enough, and therefore I would like to address this disagreement to Mr. Vaypan. What is the logic behind the proportionality principle to limit the human rights as a limitation imposed on human rights? I believe that the responses provided by the defendant could clarify largely the importance of the proportionality principle in the human rights context overall. Overall, I should say that the dissertation is in compliance with the requirements, and the defendant deserves to be awarded the aspired academic degree. Okay. Now, according to the protocol, it is the members of the dissertation board that have the floor. 10 minutes for each member of the dissertation board. So we start according to the Russian alphabet order. Professor Koskeniemi, the floor is yours. You are the first according to Russian alphabet.
Thank you very much, Chairman. I need to start by thanking the university for inviting me here into this dissertation board. It's always a fascinating situation to regard the different cultures in which legal dissertations are being submitted and debated. It is particularly fascinating when the candidate presents himself, as in this case, as a critic. And the question emerges, what is the candidate a critic of? And how those at whom the critic is directed should portray themselves vis-à-vis the critic. Now, I'm of course not going to read the written statement that I have produced. I think this is a wonderfully elegant, profound, and ambitious thesis, and I have no hesitation about the quality of it. But I have a couple of questions to the candidate that I want to pose, and I hope that the candidate, in the course of answering those questions, in case he thinks they need a response, also addresses the question of what it is to be a critic in the specific context of Russian law and Russian academic law in particular. But I have just 3 points to make. 3 points to which I would like to draw the candidate's attention. The first point, perhaps unimaginatively, draws on the first sentence that he made in making his oral presentation. In that first sentence, he said that this dissertation is about the ideas of lawyers. I wonder if that's true. I never read this as a dissertation about ideas of lawyers. Instead, I thought that this had to do with 3 other things. In the first place, I thought that this is about the logic of legal concepts, that it tries to trace an intrinsic fashion in which legal concepts, such as proportionality in this case, is divided into contrasting propositions that challenge each other and devour each other, somewhat in a manner that the snake famously eats its tail. So if it's a dissertation on the logic of concepts, I would wish to ask him, how does he situate that in the rest of the study on legal logic and conceptual logic that used to be rehearsed in some countries in the 1970s, 1980s. The second possibility is that it's not about logic or logic of concepts, but it's about rhetoric. Now, in the medieval university, rhetoric was a highly regarded discipline. It's now rather disappeared, unfortunately, from many of our modern universities. And I suggest to him that whereas his presentation here to us now today looks innovative, critical, in an earlier period of time, it would have been rather straightforward exercise in the study of rhetoric. So I asked him, how does he feel about that? The third possibility is, and I will come back to this at the end of what I'm going to say, is that the dissertation is about institutional practices, that it's about the way in which lawyers, especially in courts, because most of the cases come here from the International Court of Justice, the European Court of Human Rights, that how an institution such an international court pushes lawyers to present their cases as they are called upon to do so. So, to what extent is this a kind of institutional sociology of lawyering? So that's my first rather lengthy, maybe too lengthy question. What is the genre in which this is written? So the candidate uses expressions such as critical legal research, expressions such as critical structuralism, deep structure of legal concepts, argumentative structures. How do those notions relate to the genre in which he performs, and whether that genre itself, somehow of necessity, is a genre of critique. My second point, which is a more standard point, is about something in the thesis itself. It's about the third space. He suggests in the logical manner of his analysis that lawyers in the pragmatic modernity, whilst they are pressed between the two, between the Scylla and Charybdis of law and politics, they try to seek a third space. Now, it didn't seem to me that the logical analysis presupposed the search for a third space. Instead, I suggest that probably the Scylla and Charybdis, which he identifies as threatening the lawyers, are really the Scylla of legal formalism and the Charybdis of skepticism. So I don't think there is a search for third space. I think there's a search for law, but an understanding of law that would not be a formalist understanding, but would nevertheless not become a pure skepticism. So that's my second question. It's a question internal to the logical structure of what's being presented to us. My third point is this. But the world works. People go to work, they go to courts, they argue, some of them win cases, sometimes they lose cases, they get salaries, they get hired, they have holidays in fancy places. So it's all fine and dandy. So what on earth for are these tremendously complex logical problems being presented as a critique of something that seems to be fine? Now, if one thinks that everything is fine, then I suppose one thinks that the institutional structures themselves, and now I come back to the institutions, that the institutional structures and the institutional practices resolve the apparently insoluble logical and rhetorical dilemmas that lawyers every day, without having a knockout argument to clear the floor, are able in a pragmatic way to go from one case to another in the mundane, pragmatic way in which we deal with these cases. So where is the sharp edge of the candidate's critique? So one way of understanding that sharp edge could be to say, well, yes, it works for some people, but it doesn't work for other people. And that the fact that these practices, these institutional practices in which lawyers engage, seem to be fine and continue from one day to another, that takes place at the cost of some other institutions or groups of people suffering from the actions that these legal institutions produce on a daily basis. So is this a critique of the practice of legal institutions as somehow harmful or detrimental to the good order, welfare, and peace of the world? Or possibly, is this a critique of the institutional practices which suggests that if the logical and rhetorical tools that we have were other than the tool of proportionality, then we could avoid those logical and rhetorical dilemmas, and the institution could somehow work on a firmer basis without having to worry about the constant vulnerability of the institutional practices that are being produced. This would be a critique somewhat softer than the prior critique, which would have been a critique of the legal profession and law in itself. This would be a critique of a particular way of doing that law and the softness of its conclusions. So to sum up, and not to overuse my time, it's really great to be here in St. Petersburg to listen to the comments of my colleagues. I've learned a lot from them. I also see my colleagues come from various sides of the legal, theoretical, doctrinal spectrum. It's very instructive to be here in this context, having a debate on a dissertation, which, as I said at the outset, is particularly ambitious. It's elegant and profound. Thank you.
I'm the next on the alphabet, so I would like to present my ideas about the work. I don't have any critical comments, but as a philosopher and a specialist in logic, I would like to focus on the logical and rhetorical components of the dissertation. The work is written in the context of the modern critical and legal theory. It's a purely postmodernist work. There is nothing, there are no, without its negative aspects frequently associated with postmodernism. Minus the historical meta-narratives, the work focuses on two key concepts of principal importance to Europeans. And these are concepts we build our daily lives around. One is the concept of fairness and justice. Its derivative, the concept of legitimacy. Legitimacy is actualized in more public contexts. Justice is more universal. And the third concept is the concept of dignity. Dignity is a highly significant concept because it characterizes a human personality in many contexts. According to social and psychological studies, we sometimes refuse to take part in beneficial transactions if we understand that they are going to compromise our dignity. We sometimes fail to understand why our rights are violated by authorities engaged in even legitimate activities. And this is a major conflict involving these three concepts. They are super historical. This aspect of the work does not receive detailed treatment because this would have increased the work by 2 times at least. The things that I liked about this work are the case studies. As far as regress in argumentation is concerned, given the tenets of modern logical semantics and all the things about propositional judgments and value judgments, they can be interpreted in different manners. They may not contradict each other, but there is one field that unites them: pragmatics. In this case, the logical statements are verifiable from practice. There is discursive truth in semantics, in modern semantics. So regression or regress is only an illusion. Any conflict situation is a situation when the parties change sides and the defendant shows how fluid the situation is. However, in the end, a behavioral strategy is formed that helps us to resolve the conflict. So here you see a transition from abstract, theoretical thinking to practical philosophy. So this is what can be said about the examples that are quoted by the defendant. The activity of the European Human Rights Court and several other institutions that have been considered in the work are samples of practical philosophy, in the sense that it was understood during the Age of Enlightenment. However, the complexity of the issues is really very high and unthinkable to 17th and 18th century philosophers. So this is a really deep philosophical discourse built around the ideas of justice. In the 20th century, we have moved from feudal wars to wars of nations. So in the context of wars between nations, the concept of humanitarian rights is transformed. Humanity integrates. There is no concept of humanity as a single unified law subject, not yet. However, this idea is there. So, and this is why we have changed our thinking, the way we think about transborder issues, compared with the 1950s, for example. And this is reality, because appealing to universal values stops being a product of pure theory. Knowing that social phenomena exist in our heads, not elsewhere, this circumstance is something to be considered. So there are many interesting ideas at play in the dissertation. It is multidisciplinary. It works from the intersection of social sciences, social criticism, rhetoric, and law. The argumentative aspect is really very important, because this is how we can follow what is happening, what is taking place. It's not a postmodernist, esoteric experience. So frequently, I believe that the work is excellent, and the author definitely merits the academic degree sought. And now I would like to hand the floor to Elena Timoshina. Oh no, sorry, Violino Cinema. Thank you very much, dear colleagues. Thank you for giving me the floor. I'm joining you online, so if there are any questions, if there are any problems with the connection, please let me know. I would like to welcome you from Berlin. Thank you for the opportunity to join you on the internet. I would like to make a confession at the beginning of my talk. As international lawyers, we must admit, we must accept that Grigory Vaypan created a pioneering study. Because the dissertation is really the first sample of research, the first study based on the critical theory of law. This theory has revived a long time ago. It became widespread decades ago. However, in terms of international law, critical theory in the 1980s could be called a new movement. Nowadays, and I would like to quote Jan Kleibers, who says that this theory has become academic mainstream, if not political mainstream. I don't know if you can agree with the statement 100%, but one can say that practically everyone agrees with me that critical theory is an important ingredient, an important component of the global intellectual discourse surrounding international law. So the fact that we are taking part in this defense signals that Russian international law must grow faster. And secondly, it confirms the fact that there is a new generation of researchers who are being active in Russia and who struggle to overcome the confines of the existing legal concepts, doctrines. The dissertation displays much scientific novelty. I would like to stress that despite the fact that Mr. Vaypan uses the principles of the critical theory of law, it is clear that he doesn't use them mechanically, he critically appropriates them. His statements make it possible to specify the research area, and I also believe that one key to the success of the study was the fact that the author has been able to analyze how proportionality, the principle of proportionality, is used in different fields of international law. And now I would like to focus on some questions and debatable issues. At the same time, I would like to stress that the work is methodologically and conceptually very, very interesting and well-founded. And I do believe that it will be a hit with lawyers representing the academic circles and practicing lawyers. So question one. The defendant in his welcome speech focused on the type of dissertation that he may have written, steering clear of discussing the proportionality principle and his understanding of it. And this is something that is typical of the dissertation itself. For example, he mentions that the proportionality principle is frequently used by law enforcers when the principles and norms of international law are insufficient to resolve a conflict and need amplification. I think that if one agrees that proportionality principle is fuzzy and it can be interpreted by laws of by international law differently, it is still a component of international norms such as jus contra bellum or many human rights norms or or other components of the jus in bellum law. My second comment is related to a conclusion that the defendant makes in his dissertation relating to the understanding of proportionality principle as developing in a non-linear linear pattern. So he mentions that the proportionality principle was formed only in the second half of the 20th century and signaled the reconsideration of norms of international laws. The conclusion is based on controversial principles, including the following. The intellectual link between the modern understanding of proportionality and the historical traditions of proportionality established by 18th century philosophers and ancient Greek philosophers. Aristotle distinguished between different types of justice. So, even if in some part the ideas of proportionality did not develop in a linear pattern, they were culture-specific and time-dependent. They were situated in history. A question still arises why Aristotle may not be considered the source of the proportionality principle.
The very term of proportionality has become part of the international terminology only after the First World War, whereas it gained a higher profile after the Second World War due to the development of international law, including the human rights law. But actually, I should underscore that lots of areas of international law, such as human rights law, emerged only after the Second World War, not after the First World War. My next commentary is related to humanitarian law, which is vested in a relevant protocol dating back to 1977. However, the defendant claims that human rights law and humanitarian law has been there as a tradition. Well, I think that this is a challenging issue. Well, if we look at humanitarian law in general, in the 19th century, there used to be a very clear stratification into combatants, into the military and the civilians. However, both in the past and in the present, the international humanitarian law is based on the classification, which implies 2 or 3 categories of entities. However, the issue is how well this classification is developed. My next recommendation and point of criticism relates to some of the outcomes of the dissertation. The indefiniteness of the proportionality principle is not relative, it is absolute. The defendant claims that proportionality implies an endless use of argumentation, referring to either pragmatical approach or a values approach. This does not allow us to attach any preferences or to between these 2 approaches. However, if it is impossible to find this golden middle, the third space, therefore it is weird to read that everything is justified. This means, my question is whether such ultimate practices are applicable and whether those result in unproportionality rather than proportionality. The examples, the specific cases that the defendant shows and refers to is it possible to find some golden middle in these cases? Actually, none of them is an example of such ultimate practice. Therefore, my question is, if we think about some feeling of intuition that something is not right, something is unjust, and here I would like to refer to the case with Israel, when a bomb was dropped to the terrorist's house, where basically the Salah Jihad was, and this triggered an enormous amount of casualties and victims. And therefore, my question, is it possible to claim after this case that proportionality principle bridges everything? Lastly, my fourth point of criticism, and here I'm not being original, I would like to refer to McCormick and his article where he referred to the critical theory of law. And the title of the article was Construction After Deconstruction. Therefore, well, considering the value of the objectives and the conclusions made by the defendant, however, I would like to rather find an attempt to go beyond the method as a limit and to provide some limits to the proportionality principle, or to criticize the existing approach without focusing on two absolutely opposite points of views. Well, I think that the defendant was limited in time, or was limited, or had to follow some other limits so as to comply with existing rules. And I hope that this would be the future outlook for this dissertation. I believe overall that this is an impressive piece of research, and I would recommend this dissertation to be referred to by other lawyers, because lawyers and scientists, researchers, because it is a very insightful piece of investigation in international law. Thank you. Thank you so much, Vera. Now, Elena Timoshina, this is your turn. Well, Grigory has already referred to his dissertation as something which violates the standards, something which is innovative, and I actually agree with this assessment. Professor Kuskoniemi also referred to this dissertation as an elegant and a very deep piece of research, and I agree with Professor Kuskoniemi as well. I also agree with the previous speaker that sometimes we see how professionally the defendant opts out from referring to some specific most acute challenges. I believe that, to me personally, the value of this dissertation is that it is a critical assessment of the proportionality principle in contemporary legal practice. This analysis presented in the dissertation is impressive. It is brilliant. I'm not going to read out my report and to refer to all the recommendations and points of criticism that are in my report. I would like to focus on 2 points of criticism and 2 questions that I'm actually I'm excited to have answers. My first question is about the innovative interpretation of proportionality as an endless process of legal argumentation, and therefore my first question is just an idea. It refers to the theoretical part of the proportionality principle, and my second question is about some more practical aspects of proportionality principle as a logically endless argumentation process. Well, my questions are related to the fact that the logic of your dissertation would benefit from being more consistent. And therefore my question: what do you think when you refer to principles of law? I believe that to be able to justify the proportionality principle as a second-order principle, it is important to understand what is the proportionality principle of the first order. Grigory, you underscore that proportionality principle as a second-order principle is not equal to pragmatic interpretations or formal interpretations or dogmatic interpretations, but what understanding is behind your understanding of law and principles of law? My second question is again about proportionality principle, which, according to you, Grigory, does not imply it implies the agreement on existing rights and liabilities that are vested in the existing international law. So this means that there is no regulatory content behind the principle of proportionality. Although, whereas the first-order principles do have such a regulatory content. On the other hand, quite often you claim that the proportionality principle compels to do this and that. You claim that the law applier has to agree on interests. You claim that the proportionality principle compels to make a decision which would be somewhere in the golden middle, and the law applier has to ensure a proportional outcome. And therefore my impression is that the proportionality principle somehow shapes the rights and the liabilities of the law applier, and therefore it has some normative content. It has some regulatory function, and therefore it determines rights and liabilities. Your idea that proportionality principle belongs to some different legal reality, and therefore my question: what type of reality is that as opposite to the first-order laws and liabilities? The proportionality principle, according to you, is counterproductive in terms of its normative content, regulatory content. I believe that this is something that deprives your dissertation of its elegance. So you have to justify, have to explain the proportionality principle as an obligation, as a regulation and its regulatory function. So this is something to be clarified. My next idea is that all these issues are related to the idea that proportionality principle is implemented by international courts when the international law is exhausted and there is a necessity to refer to some other tool, which is basically the proportionality principle. So proportionality principle is implemented to bridge some gaps in international law when some other legal tools are exhausted. This means that proportionality principle is usually referred to as the technique of last resort. And therefore, my questions. What do you mean by other legal tools? It is not clear how can you identify that specific legal tools and principles are exhausted, they have exhausted their function. How can we identify the point when these legal tools are invalid? They are exhausted and they cannot be applied. My impression is that when the law applier addresses to the proportionality principle, this itself testifies to the fact that the existing laws and regulations have exhausted their potential. Then, wouldn't it be wiser to clarify the existing laws so that then there would be no necessity for proportionality principle? Once the judge addresses the proportionality principle, that means that the first order international laws and regulations are invalid. But I believe that this can be addressed to the Besant's idea when someone's subjective argument on the absence of some specific norm, legal norm, is understood as the impossibility to implement the order of law. Those are equal statements. So this basically justifies the implementation of the technique of last resort, which is the proportionality principle. And lastly, it is unclear how does proportionality principle clarify the norms and principles of international law, provided that, as Grigory claims, that the violation strategy allows to escape from addressing the very essence of an argument, of a legal argument, of a legal conflict. And there is no way back. Then, how come that proportionality principle is a benefit to eliminate, is beneficial or is practical to eliminate existing collisions? My second argument refers to some practical aspects of proportionality principle as an endless process of legal argumentation. I would like to underscore that the proportionality principle and the interpretation that you suggest is indeed justified. It is brilliant. So the criticism of the proportionality principle was so fascinating to read. I read it as a novel. It is thrilling. And I was anticipating some very thrilling result. However, I was a little bit disappointed by the way you resolved this conflict. Nevertheless, whatever it be, the defendant claims that this dissertation has an innovative, analytical and critical interpretation of the proportionality principle. So, and yes, indeed, the perspective that Grigory establishes in his dissertation is favorable for future legal practices. However, what is strange to me is that the criticism of proportionality principle resulted in the fact that there is no alternative to proportionality principle in international arguments and conflicts. Well, of course, proportionality principle is an exciting dimension. However, alongside with the benefits of proportionality principle, we know that there are lots of collaterals. There is a lot of harm. So then, why is proportionality principle not the aspired outcome? But the dissertation overall is very contradictory. There are lots of contradictory statements. On the one hand, the defendant justifies the proportionality principles. On the other hand, he suggests some alternatives to proportionality principles, at the same time subverting these alternatives and exposing how invalid proportionality principle is. So what allows us to discern between better proportionality principles and worse proportionality principles? Grigory refers to stereotypes and subverts the very principle of proportionality, but in fact, he suggests to stay where it is, and to put up with the faltering principles of proportionality. And accept whatever limits imposed on human rights and the violation strategy, the resolutions of courts being non-transparent, and so on and so forth. At the same time, however, the proportionality principle is regarded as an only alternative. Or to be more precise, such alternatives have no reason. And therefore my question, does this framework that the defendant suggests, the understanding of proportionality principle is an endless process of argumentation to somehow heal these drawbacks? Or shall we just accept it? Well, the discussion, the philosophy of discussions allows us to have such an endless process of argumentation, but, however, an endless process of argumentation is usually seized by the ultimate ruling of the court, after which no argumentation is possible. That actually puts an end to any arguments whatsoever. So what do we have to put up with? This is the intuition that tells us that something is not right. So I have to refer to Petrozhitsky and his idea of intuitive law. When you speak about the fact that, as you said in your introductory word and introductory statement, that your research is beyond all types of understanding of the law. But once you speak about the intuitive feeling of injustice, this, of course, allows us to conclude that you are within a legal framework. And once again, referring to Petrozhitsky, what is natural law? Natural law is autonomous legal doctrines and their implementation. And therefore, this idea of intuitive feeling of injustice made me pose this question. Whatever it be, I join my colleagues in claiming that this dissertation is in conformity with all the existing requirements, whereas Grigory deserves to be awarded the Inspired Academic Degree. Thank you.
Thank you. And finally, the review by Vladislav Tolstoy. Thank you. I will be the last one, so I will be repeating a few things here. And I would like to sound with words of praise, because the things that I liked most about the dissertation is the way the defendant identifies the types of proportionality and trace how they work on in different court orders, in different decisions. This part of the dissertation enriches the national legal doctrine. As far as the concept is concerned, I have several serious comments, several critical remarks. There are three. The first is related to an unfortunate attempt to build one's own understanding of proportionality, because the author has tried to find this definition within the traditional history of international law, but for some reason he did not look at proportionality as a universal principle in law. The author hints, literally hints, not registers, but hints that this definition can be found within the framework of modern theories like the analytical school of law, the second-order principle. However, this idea did not receive any serious development. Finally, I see proportionality as a deep basis, deep foundation of the law. It's related to the ideological level of law, and in describing it, it may have been beneficial to use philosophical terminology. It would be possible to call proportionality a myth, an idea, to use a different term, and to show how it relates to other terms or myths or constructs. However, this hasn't been done. My second remark relates to the origins of the proportionality principle. The defendant relates this principle to dogmatism and says that the origin of the principle can be traced back to the 20th century. However, this would be the same as to say that the Second World War occurred because of Hitler and nothing else. because this is an attempt to indicate that systemic phenomena in law are just accidental or arbitrary. This is a myth. This precludes us from saying the reality that is should be open to philosophers and lawyers. So the defendant may have used philosophical instruments, philosophical tools to trace the origins of proportionality. I wouldn't say they should be traced to Aristotle, but definitely the 15th and 17th century, the metaphysical philosophy, St. Augustine, St. Thomas of Aquinas, Hume, Berkeley, and Occam. So they were at the inception. They were there at the inception of the proportionality principle. The legal arguments came to be interpreted as a conflict between different elements in physical or conceptual reality, which is really very important. My third comment is to do with the way you resolve the situation. The defendant writes in his conclusion that better results should be suggested using the proportionality principle. Now, there is some contradiction in terms, because the author shows that the principle of proportionality is inconsistent. However, on the other hand, there is a contradiction between this principle and intuitive law enforcement. When I was listening to this, I kept thinking about one of the founders of international law who, back in the 19th century, in the 16th century, said, please do not do something that you are not competent to do, something that you are not qualified to do. Now, this is something that is absent from the school, in compared with Vitellini, for example. In destroying the existing concept of law, the critical school does not suggest any new recipe for resolving conflicts. I may have exceeded the time limits, but there is an extended comment that I would like to make in this field. When I was starting to learn about the history of international law, I was fascinated by the fact that ancient Greek law somehow, even in the presence of well-developed rhetoric, and complex philosophical systems like Plato's or Aristotle's, the legitimation theory the conflict resolution, they said, had to be based on love and justice, and so did the medieval lawyers, medieval legal schools. So this appeal to supernatural reality is really very, very interesting. So this thesis can be formulated as a question. Does the author think that one possible solution to the current conflict with the proportionality principle is religion? And my next comment is to do with the style of the work. The work is probably oversaturated with quotations, and it fascinates at the beginning, but starts irritating somewhere towards the middle of the text. Because one must be really careful not only about the essence, the content of the dissertation, but also about how it is presented, about the presentations. So the quotations are very often difficult to trace. It's not clear whether there are references to something said by somebody else, or whether these are ideas expressed by the author. However, this can be used as a tactic on the part of the author to avoid formulating the principle of proportionality by himself. At the same time, I would like to agree that the dissertation is brilliant, it's innovative, and the author definitely deserves the academic degree being sought here. Thank you very much. Now the defendant may have his 15 minutes to address all the questions from the external reviews and the members of the Dissertation Council. I'm sorry, I'm not texting anyone. This is a timer. Thank you. To be able to address all the questions, I will need 115 minutes, not a quarter of an hour. So I have grouped the questions I have heard. I have identified several veins, and I would like to apologize to those members of the Dissertation Council who will not hear their question addressed in exactly the same formulation and exactly the same wording as they used. So before I pass on to the three groups of the questions and answers, I would like to resolve this indeterminacy of the genre that Marty Koskaniemi mentioned. In my study, I was looking at the surface structure of the legal distance, the idea of equivalence, the idea of balance, the idea of proportionality. The superficial ideas overlie, as Marty has justly said, the internal logic of proportionality. Now, this is the genre, and compared with other studies, including critical studies, which emerged in the 1970s and 1980s and are still ongoing, very few researchers until now have looked at pragmatic concepts like proportionality or discretion, sensibility, equity. I'm under the impression that the key impulse for the critical theory and its best examples are by Marty Koskaniemi, and a number of other authors who try to dissect concepts like sovereignty, sources, customs. The classical notions have been deconstructed, and argumentation around these concepts has been studied. The final analytical point behind this deconstruction was sensibility, resorting to sensibility. Now, grid shows that the notion of sovereignty is not an answer. The concept of customs is contradictory. And I wanted to make a further step and to look at what is happening in the proportionality world once the lawyers are there. This is an amorphous space where everybody wants to say anything. However, this is only an illusion. It's also a discourse where not everything can be said. To be able to participate in this discourse, you must know how it works. You must know the rule it is governed by. I'm thankful to my reviewers for this fantastic number of questions and comments. It's great that there are so many opponents at the dissertation, and there is much more dialogue compared with traditional defenses that I took part in when I was a PhD student and an undergraduate. So the questions break into several fields: the nature of proportionality, the theory of the origins of proportionality, and finally the outcome. So let us individually. The question about the nature or essence of proportionality as far as this is concerned, I'm not trying to avoid the question of proportionality or what it is. This question can be answered is answered by lawyers worldwide, but it's impossible. I would say it's impossible to define proportionality in such a way that is consistent with the lawyer's understanding of law and politics or policy. There was one comment by Mr. Dolchikov, Dr. Dolchikov, that the topic of the dissertation is not consistent with the essence of the research. I keep emphasizing this difference between I keep the questions about the essence or the definition of proportionality is not the essence of the study. What is interesting is how lawyers discuss this notion and how this discourse identifies the internal contradictions within this concept. So proportionality as a tool, proportionality as a method that is used by law enforcers. At the same time, the mutual relations between proportionality and other concepts and other principles, a question that was addressed by Elena. I'm saying that proportionality is not identical to principles and norms of international law. The question was, what are these principles and norms? In the first chapter of my work, I'm talking about two principles of international law in Russian and world science. The first understanding of proportionality is formal and dogmatic, something that our science, Russian science, still works with. The principle of international law as being driven by the supremacy of international law and the principles that have clear normative substance, the principles of non-interference, territorial integrity, sovereignty, adherence to international commitments. They can be deduced. So these principles may underlie many decisions, such as whether the war in Syria was legitimate, or a war in Yugoslavia, or the war in Yugoslavia. I associate this vein of thinking with Dworkin, the idea of principles as a vector. So the theory in the second half of the 20th century does not allow one to make a conclusion about the legitimacy of a particular behavior. So there is the principle of territorial integrity, and there is the principle of adherence to international commitments. So if one state attacks another in order to prohibit in order to impose the restrictions on the use of chemical weapons, there are two conflicting principles at play. Each of the principles has benefits, has advantages. So Alexei and Dworkin agree that principles can be used as arguments. And principles have weight or importance, and they're comparative weight and comparative importance. When I'm saying that proportionality is identical to neither, I'm talking about the subjective perspective, or the perspective of the subject, of the legal subject. When law enforcers, lawyers, judges resort to the principle of proportionality, does that mean that the principle of territorial integrity is not working anymore, is not usable anymore? No, it does mean that the subject, referring to the principle of proportionality, acknowledges automatically that the principle of territorial integrity or the factus observando is not enough. And this has clear legal repercussions. Practically, it means that the lawyer who has crossed from the reality of principles as the key norms of international law or principles as arguments to the reality of proportionality is unable to return to norms and principles of international law without knowing what proportionality is. So with all due respect, when Vladislav disagrees with me and says that there is no indeterminacy in the notion of proportionality because, quote, the legal decision is not wholly arbitrary, a good judge operates with just the values and norms that are suggested by the norm of the law. Now, this is the logic that is totally excluded from our understanding of proportionality as the last resort. If we are in this proportionality space, we cannot go back to norms and principles. So there are no other norms and principles of international laws that we can resort to. We are just left with this dichotomy of fact and value and everything that happens when they interact.
The second aspect is about history and genealogy. Well, actually, it's possible to say that all legal notions and concepts that we have been referring to today have a long-running history, and all of them can be. All of them are about some very regular categories, such as the category of justice, the category of equality, so on and so forth. And therefore, my question, what do we yield from this abstract genealogy, as Vera said? Well, we can look at Aristotle's ideas, but may I remind you that Aristotle looked at the concept of virtue, and to him virtue was not something which was a matter of argument. There are virtues and there are non-virtues, and this is basically it. So there was nothing to argue about. There was no contradiction about these concepts, and therefore Aristotle said that proportionality is somewhere in the middle. And therefore, I urge you to refer to Hans Kaysen's paper, which he produced in 1950s. And he refers to different concepts of justice. To him, the Aristotle's concept has no sense, because in Hans Kaysen's world, a value is a matter of argument. Therefore, to him, the Aristotle's concepts of virtue and proportionality are absolutely void. Of course, there is a golden middle. We can divide a specific distance in two parts once we know where it starts and where it ends. So once we know the two where it starts and where it ends, then we can find the golden middle. Therefore, all these principles and weighing all these principles would not have generated so many arguments that we are presented with at any court case. I believe that the abstract notion of the proportionality principle would result in an opportunity to, for example, cover the entire history of this particular building where we are having this dissertation and this defense today. This building is over 300 years of age, and initially it was a palace, then it was a university, a bank, and even an English coffee club for several years that was housed in this building for some time. Therefore, what's the value behind looking at all of these functions of this building? It's just for referral. It does not provide us for any understanding. We would just know what this building housed in, well, for example, 200 years ago, but this would not give us any understanding of how to cook very good coffee that used to be cooked here 100 of years ago. So you address the notion of humanitarian law, and this makes me truly happy. I read papers referring to the civil defense in the first half of the 20th century.
Когда узнал, что в районе 1920-1930-х.
So I read that in 1920s, 1930s, the international humanitarian law has experienced a huge rupture, an intellectual rupture, because I believe that this is the unleashing of a war in the air. It is different from what Lermontov, the Russian writer, used to describe as the theater of war, because there is no battlefield, basically. Of course, you may have it right that civilians and the military, this discretion used to be there always, but in the 19th century it was irrelevant, because the civilians were not at the battlefield of Borodino. It was in the rear. Whereas in the 20th century, an aircraft emerged as a tool of war. And we see how lawyers started to get engaged into conferences so that to ensure that it is possible to unleash wars, but without so many casualties. So what we see is the emerging of new intellectual concepts, such concepts as the associated harm or collateral damage. So this is something that was lacking in the 19th century. There was no necessity to compare the benefits and harms. This concept emerged in 1923 in the Hague Rules of a war in the air. So this actually provides us with a perspective of how to interpret proportionality. And that provides us with an insight of what is behind the principle of proportionality. Therefore, I do not discard the tradition, the very notion of tradition here, but I believe that these intellectual ruptures and the very notion of proportionality allows us to develop an insight into how the implementation of proportionality principles is challenged today. Well, I see that I have exhausted my time limit. So what is actually the outcome? What am I getting at? All the points of criticism were valid.
Вы можете ожидать услышать определенные замечания и не услышать другие.
So, and I actually expected to be presented with these points of criticism. Those could be split in two types. The one type is that my criticism and my critical analysis is invalid because it is just a vicious circle. So it is the murky water. It's a very well this is a very well-known logic, but this is only half of what I'm going to say. Although proportionality allows us to make any decisions of this kind would be vulnerable. Once again, as I said, and the attack on one of the Palestinian terrorists was referred to as a case in point to show where situations when criticism does not work. This attack is no different from the Milan-Martic attack that I referred to in one of the cases, basically the Gotovina, Cermak and Markac case. Such offenses are yet not the most illustrative case that the international law is presented with. One of them is the ultimate case is the nuclear weapons. Lawyers cannot still agree on when nuclear weapons and implementation of nuclear weapons is unproportional. Those who believe that nuclear weapons is defended by lawyers of specific ideology, those I would advise to read the paper by Ross and Higgins, the United Nations judge, who described the dilemma of proportionality. This means that lawyers cannot agree on proportionality or non-proportionality of implementing nuclear weapons. I mean, argumentation is the force. It is all the essence. It is not the term, but the way you use this term. Force is the argumentative structure used by lawyers. And here I would like to refer to the second type of criticism.
Что оно, я бы даже сказал, вредное, не просто бесполезное, а вредное, потому что оно отвлекает от...
This actually allows us to disembark from more relevant agenda. Instead of doing such engineering, you would rather be more practical. But I do not think that my dissertation as a critical paper does not mean that we should disembark, we should do away with all other approaches. I use formal dogmatic argumentation as well as other modalities of argumentation, but I believe that today, amid current realities, none of those is more or less favorable. And here I would like to refer to other critical findings done by my colleagues who deconstructed these principles of understanding. Therefore, there is no better alternative, abstract alternative to the proportionality principle. However, this does not mean that there is no positive agenda. A positive agenda is always there, and the positive agenda in this case is that although proportionality is not a good thing, neither is it a worse thing, but the very context has to be evaluated by those who implement the proportionality principle. And here I would like to refer to the review submitted by Professor Krasikov, who asked the following question: what should we do when states are against, or governments are against, codification of proportionality? It's a good question, actually. If we look at history, we see that in different contexts, proportionality was treated differently by governments, by other agents. For example, when the first additional protocol was codified, there were two parties. The one party said that proportionality cannot be codified. It does not lend to codification because otherwise it would limit the freedom of interpretation. And there was an opposite position, claiming that proportionality cannot be codified because it subverts the civil standards. So proportionality can be a beneficial tool and it can be harm as well. No one would deny that in Russia over the last years, the proportionality principle, well, that's my intuitive attitude, it was highly relevant for the reform of Russian law. And it contributed largely to the well-being of Russia. I mean, this is the proportionality principle in the first article of the first protocol regarding the rights of ownership. And if we look at Murat Vural against Turkey case, there are similar limitations. This case echoes largely similar cases in Russia. In that case, the person considered legitimate the historical memory. It's a highly controversial issue. So what we see basically is that one and the same court can interpret the principle of proportionality differently. So what is positive about my dissertation?
Юристы-исследователи должны исследовать эти контексты.
It is a call upon lawyers to investigate contexts and to be more responsive to contexts. This is what we should be investigating in the future. And here we result in institutional practices, what Martin Koskeniemi referred to. Therefore, my idea is that existing approaches, the mainstream approaches, and the criticism of proportionality are limited by the fact that those are abstract. Tons of papers are written on how to formulate proportionality principles. And those are just, those are right, but we should understand the limit. We must understand where those would fail always. Next, this research is done at the expense of different research that would look into the benefits of proportionality and the harms of proportionality. This is how I would pose my question. And this is my response to the question submitted by Martin Koskeniemi on what does it mean to be a critic amid Russian realities. Thank you so much. Thank you so much for your responses. Now, according to the rules of procedure, I have to open the floor for open discussion. But we have largely extended the time limit, so let's be brief. If someone would like to take the floor, please be brief. Keep it short and simple.
И держите микрофон.
Работает, да? Да. Когда его? Да. Только
2 минуты.
2 minutes. Yes, I'll be brief. For the first time, I'm present at a defense of a dissertation. But I used to participate at defenses, PhD defenses or MA, master's degree defenses. So I'm overflooded with emotions. Well, I have, however, some concerns. And those concerns are the following. I had an idea that Vaypan's dissertation lacks practical relevance for Russia. And this actually justifies the fact that Russian lawyers and international lawyers speak different languages. Therefore, it is so difficult to find some common grounds on what proportionality principle is. Next. One of the members of the dissertation board said that this dissertation lacks a true landscape of the world and referred to Hitler. I think that this is a worrying trend to consider that once you have the clear understanding of what's going on in the world, this is when actually is the best time to remind of Hitler. So what is proportionality? I think that an answer is there in Vaypan's dissertation. I think it is where Grigory compares proportionality to other alternatives. I believe that any laywoman would understand what proportionality is if she would interpret proportionality as a recipe in a cookbook. She would take some vegetables, but what she would ultimately cook would be absolutely unedible. So proportionality is not just a whimsical selection of some ingredients and an outcoming dish, which is basically the resolution of the court. But it is about what are the proportions between the vegetables, the spices, and if we overdo it with salt or pepper, then it would be something unedible, and on the contrary. So, if it is unclear how it works in Russia, Well, it works as we select everything haphazardly and we put it in one pot. And well, what we have is what we have. Enjoy. Thank you.
After no more questions or comments, the defendant may address the questions and offer his comments. If you don't have any comments, if you would like to leave the questions unanswered, we will give the floor to the research advisor. I will be really brief. The word unusual, or should I call it non-standard, has often been used in relation to this defense. So there have been a lot of non-standard things or extraordinary things. Extraordinary student. Because ordinarily we work with students who come and say, give us a topic, name the subject. This researcher came with a clear subject and a clear understanding of what he wanted to do. So I didn't have to act Pygmalion. I only did the editing because I sometimes softened certain things or improved on the wording, improved on the terminology used. But as we were discussing the work, we kept thinking about the possible comments. We knew what you would ask here today. What makes this work extraordinary is that is one clear thing. Most good quality dissertations list or enumerate different viewpoints. The researcher tries to navigate between the differing viewpoints without taking sides or causing offense to anyone. Grigory, however, has his own approach, his own viewpoint. He knows no authorities and sometimes can sound categorical. Sometimes his conclusions may sound provocative or spark criticism. Which is something that you could read between the lines of the reviews. Some other things that can cause controversy in connection with this work. Include, as has been said here today, certain detachment or certain abstraction that the defendant practices in his reasoning. So where is the practical relevance? One may ask. This level of abstraction causes psychologically causes suspicion. How are we going to use the proportionality principle in the European Human Rights Court or anywhere else? In my understanding, the work makes for highly intellectual reading. It's a highly intellectual study which will be understood or appreciated by very few people. I don't think that it will become hugely popular, but this is a rare pleasure to read. On condition that you know something about the subject. I would compare this dissertation with haute cuisine. Because many people try it, but very few people actually appreciate it. This dissertation is a gourmet dish. Vera has said that all our students will be reading this work. However, very few will appreciate it and agree with it. I would like to comment that the work is indeed exceptional. I'm happy that I have this PhD student. I was happy to work with him, and I do believe that he deserves the academic degree sword. Thank you very much. Now, the Dissertation Council must now discuss the paper. So I would like to request you to leave the auditorium. We will be staying on Skype, but I would like you to switch off the online broadcasting. So can you please leave the auditorium for a short time?
I am for the dissertation for this. But it will be approach to this information system. Okay. You can do some alternative handout, let's say, I support.
Let us now start the open voting. So, Professor Martin Koskaniemi, what is your vote? What do you decide? What do you think?
Approved.
Dobré. I'm the next on the alphabet. I also vote in favor. Vera? I vote in favor. I approve. Elena Timoshina? I approve. Ladislav? I approve. Thank you. The vote has taken place. Now we must make the decision about awarding the degree to the defendant. We have all said yes, so the decision is positive. Everyone supports it.
So, distinguished defendant, you may have the floor for your final address. 2 minutes. Well, now I'm not going to speak about proportionality. I'm going to extend my gratitude. Well, gratitude is like the...
Прежде всего, членов Совета, научного руководителя,
It's like credits to a movie.
которую они провели.
Especially when the movie is long, when it is running for over 3 hours, no one is interested any longer in the movie. So, first and foremost, I would like to extend my gratitude to my research supervisor. He was of such an ultimate value to me. I also extend my gratitude to members of the Dissertation Council from other cities of Russia and even other countries, as well as St. Petersburg University for enabling to have my dissertation and my defense there. I believe that St. Petersburg University is at the forefront of the dissertation defending practices. I'm grateful to everyone who guided me. Those are the Dean, Mr. Milov, and Docent Shestakova, as well as other groups of people who I would like to extend my gratitude. This is a must. I'm sorry for being so wordy. All of them, apart from my research supervisor, assisted me in my way towards this defense. They were always together with me. They were arguing with me. They were trying to subvert my ideas, and was so happy to have these great people. Those are David Kennedy and Duncan Kennedy from Harvard. I'm a student of both of them. David Kennedy was the supervisor of my master's dissertation. The ideas that I put forward in my master's dissertation are echoed in my dissertation, this PhD dissertation as well. I would like also to extend my gratitude to people from the Global Politics School in Harvard, an Angepino event. They were a great company, professional company, I mean. And there's yet another person who is my informal research supervisor. This is Gleb Volsh, docent of criminal law department of the legal faculty at St. Petersburg University. Next, I would like to extend my gratitude to my colleagues for the Institute of Law and Politics, because I was at an academic leave for 5 years. So this was an excuse for me not to go to work regularly, and I would like also to extend my gratitude to Madam Fedorovich for her support. And last but not least, that my family today, we are having my grandfather and grandmother. They are professors of St. Petersburg University and Moscow University. My mother, my brother, who is a postgraduate student. My family urged me to finish this dissertation. So I was always reluctant to visit family dinners, because every time we had a family dinner, I was presented with a question, how's your dissertation doing? And that was not the question that I loved. I also would like to extend the gratitude to Sasha and the little Alisa. They're over there, the baby Alisa. Well,
языке, то есть Саша может меня,
well, Sasha is always my partner. She argues with me. She can subvert my ideas. She has a brilliant education. And this dissertation, actually, is the first project that I did without her support. This makes me proud of it. She was just a third party. Whereas Alisa, well, she urged me to finish this dissertation as well, because she always reminded me about how slow I am. I actually planned to finish the dissertation before her birth, but actually I failed. Then months and years flew by, and Alisa started to learn walking. She started to sing songs. She can now play various games and actually simulate the defenses of a dissertation on a playground. But I was still failing, so thank you so much. Now I have delivered on all my promises. Thank you. So we had the last address of the defendant. So 5 in favor, none against, no abstentions, so we can adjourn the meeting. Please switch off the broadcasting.